Hi, I'm Sandhya Surendran. I'm a technology, media, and entertainment lawyer. I've been focusing on the music industry, and I realize it's a niche area. There's not too many people who do it. It's something which is close to my heart, and I'm fascinated by how copyrights and royalties work. Given the kind of difference that we have in the Indian film and music industry versus the global scene. So I think let's get started with this session. A copyright is basically a bundle of rights that's granted to someone who has created an original work. So it could be something to protect your right in terms of an original screenplay or a song or even a sound recording or a film. So the reason I mentioned these four things is because the categorizations in copyright law in India are also based on these. So you have a copyright that's given to a literary, musical, or dramatic work. You have a copyright that's granted in a sound recording, and you have copyright that's given in a cinematographic film. So basically, music, literature, and your films, right? And like I said, it's a bundle of rights. So there are a whole bunch of rights that are kind of associated with owning a copyright or having a copyright in something. And you don't need to register a copyright to establish a copyright. So unlike your other intellectual property rights like trademark and patents, which need to be registered for them to be acknowledged or to be established, you don't need to register a copyright for it to be, established or acknowledged. So the minute you create something original, a copyright is, automatically established. So as long as you can prove that you have published something or that you have communicated something to the public, that pretty much kind of establishes the date of your copyright. So that said, that doesn't really mean that you shouldn't register a copyright. It just means that if you do register a copyright, you don't have to prove ownership, as opposed to not registering a copyright. And in the context of music, perhaps, you might have put up a tune on, say, Instagram or SoundCloud, and the date that file is uploaded is the date your copyright is automatically established, right? And that is, so to speak, like a communication to the public. And they also, there used to be this whole concept of a poor man's copyright, which was essentially back in the day when you mailed yourself a copy of what you've written, or maybe a tape of the music that you've created. And that's basically, it's creating a timestamp. Since today in the digital world, you don't really need to do that. So you either have people mailing themselves or uploading it, like I said, to a SoundCloud, or if you have a screenplay or a movie which you have shot and you want to like basically protect it, that's something that you can mail yourself. The whole concept of copyright is something which has been created to protect creator rights. So in the sense that if I'm an artist and if I'm putting out original content, if it isn't protected, or if I don't have some means of ensuring that people don't steal it, why would I want to put out original content? So there has been this debate about copyright in terms of, do we need all these stringent laws? Do we need protection? Doesn't that curb creativity? So I think there has to be a balance that has to be drawn between the two. And I think that's pretty much what most copyright laws try to establish. And the foundation of it is from the Berne Convention. And you have like about 174 countries who are signatories to it. So which means any country that's a treaty to, as in a signatory to this treaty, is basically bound by similar copyright laws. And you have the same kind of copyright protection extended to people who are members of these countries. So basically, if I have a piece of original work which I have, registered under Indian copyright laws, I can expect similar treatment to any similar treatment for the original work in any of the other countries that are signatories to this particular treaty. Just that the term might differ. So like, for example, in India, the copyright term is 60 years, which is 60 years in terms of a sound recording from the date of publication, 60 years from the date a movie is released, and 60 years in terms of a musical composition or an artwork or lyrics or a screenplay would be the duration of the author's life plus 60 years. But I think in America, you have a different period. It's 50 years, if I'm not mistaken. In Malaysia, you have 70. So it keeps differing from country to country. So the whole concept of the Berne Convention is that the protection accorded to this original piece of work will not be lesser than what is provided in the home country. So even though America is 50 years, I will still be provided 60 years because it's 60 years in India. But I think it's also important to understand that a copyright is not to protect an idea. A copyright is to protect the expression of an idea, the original expression of an idea. So, I mean, I always give this as an example, even in my boot camps, that if you've seen the movie The Social Network, there is this bit where the guy who plays Mark Zuckerberg basically says, you had an idea to create a chair. I just created a really great chair. So it's the whole concept of a chair is not unique, but it's the way I've expressed it that is unique. So therefore, that is copyrightable. In terms of a song or in terms of music, you have two aspects that apply there. Like from what I explained in terms of how copyright law applies in India, that you have copyright that applies to a composition, that is to a tune, and a copyright that also applies to the sound recording. So you have two separate independent categories for copyright in music, which is why copyright is given so much importance in the music industry, because a chunk of the copyright law applies to the music industry. So in terms of how a copyright would be split, if I am an artist who signed up with a label, as the composer of the tune, and say, for example, I have written the lyrics. So I've composed the tune and the lyrics, so therefore I own the copyright in the composition and the lyrics of the song. But the sound recording itself is going to be owned by the label because the label has paid for the production, and therefore they own the copyright in the sound recording. So when I mentioned the whole bit about the duration of the copyright, there is a catch there because obviously a sound recording will therefore expire sooner than a composition because you have 60 years from the date of publication of the sound recording versus 60 years from the day I die for the ownership of the composition, after which it goes into public domain, right? So what labels usually do, they release remastered versions or re-recorded versions so that the copyright term gets reset. And that's like, it's a business at the end of the day. So the way they kind of operate is to make sure that they keep earning royalties from a particular song, even though the composition itself is in public domain. The ownership of the composition is referred to as publishing rights, and permission that you need to take from the composer or the lyricist of a song to, create derivative works or create a copy or create a remake. And master rights would be the ownership of the sound recording. And if you're using the sound recording, so for example, a remix or a sample would be using the original sound recording. And therefore you need permission from the person who owns the sound recording, which in more often than not would be the record label. So the whole concept of master rights and publishing rights is very, very important because it basically splits the copyright into two aspects. And one is governing your sound recording and one is governing your composition and lyrics. So in India, after the 2012 Copyright Amendment Act, performers were given, economic rights, or they could actually monetize their performer rights that they've had in a song, saying that, they, as the singer of a particular song, they have the exclusive right to be able to perform it in public, have that performance recorded and monetized. So basically you have, three aspects. Of course, the performer rights is not as heavy or as all-encompassing as the ownership of the composition. It's only a part of the entire copyright. And the duration of that is 25 years, which is 25 years from the date of publication. It's important to understand in this entire context that each copyright, that is your copyright in your master rights and your copyright in your publishing, that is copyright in the sound recording versus copyright in the composition, have the rights, like I mentioned about it being a bundle of rights, right? So what is that bundle? That bundle is basically your right to create derivative works, your right to perform it, basically reproduce it in public, your right to copy it meaning basically duplicate it, and your right to earn royalties from it. But as the composer and as the performer, you are allowed and you are entitled to moral rights, which is basically your ability to claim that as your work. They call it the right to claim paternity, and the right to object to that original work being distorted or used for a purpose that is not what it was originally planned for. You have, and now moral rights is something which you cannot assign or you cannot waive. And your right to receive royalties is something which you cannot waive. You can assign it, but you cannot waive it. That is something which is very, very important and crucial in understanding copyright law. And it is also re-emphasized in the 2012 Amendment Act. And it has become all the more important now to understand this amendment, because the industry practice is very, very different. The industry practice, in fact, labels actually ask you to waive your moral rights and to also waive your right to receive royalty, which technically speaking is not even enforceable. So I mean, honestly, personally, if you ask me, I don't understand why labels include that, but I guess it's also a form of, saying that, okay, we've paid you a lump sum, so that will be considered as royalties for future, or we will assume that what you have done is a work for hire. Now, again, you cannot call it a work for hire. Like, for example, a music composer who's worked in a movie will not be, even though they want to structure it as a work for hire, music composition is not considered a work for hire because it's a creative art. And unless it's maybe in terms of like a jingle or a brand commercial ad kind of thing, where a brand is paying X amount to have someone compose a jingle or a tune which is going to be used in an advertisement, where the tune itself is not being monetized, it's being used to promote a brand. So in those instances, you can have it as a work for hire, but you cannot ask the composer to waive their moral right. So even if I am a composer of a jingle, I still have the right to claim it as my work, because that is a right that is granted under copyright, that the creator is allowed to claim something as his or hers original work, of course.